Hello, CRJ400. This is Professor Kelly Hamilton. I get the joy and the privilege of working with you throughout this Term 5, 2014. And want to come to you through videotape today to emphasize the importance of the final exam assignment. We're going to talk about that here in a few moments, but I hope you had a great weekend. I know I did. We had multiple family reunions, and my wife and I celebrated by going back to the place where we met 24 years ago on Sunday. And we went back to a place, it was the racetrack. It was Scioto Downs racing track. She was walking out, I was walking in. We saw each other, and I will tell you that yes, in fact, I do believe in love at first sight, because it happened to me and it happened to her. We weren't looking for love, it just so happened to hit us. So 24 years later, 4 kids, 22 plus years of marriage, we went back to that same site. And when we went back to that same site, I will tell you, it was just, it was nice. It was enchanting, and it was nice just to be together. So let's talk about this final assignment. Final assignment is very important. I want to give you an understanding of what we are embarking upon. We've already started the journey. I've given you many different assignments, many different reading assignments. One of my favorite was from this book right here, The Supreme Court Elite. Now, using the available copyright laws, we were able to examine some of the materials from Poe's book here. And we're going to continue looking at other books. I've also shared with you Lipsky's A Citizen's Constitution. I like this one so well because it takes the constitutional clauses, phrase by phrase, almost line by line, and will give you some understanding. We, of course, did that as it relates to Article 3, dealing with the court. Now, last week I shared with you Lawrence Baum's. Now, if you remember, I told you in the notes that I shared with you in the agenda was that Baum's book is probably the 1, 2, maybe even 3 top primers on Supreme Court material. As we take a look at the 6th edition of Baum's book, I want you to recognize there is an 11th edition out, and I contemplated, do we use that as our book to guide us through the summer? I really like the book. It has a lot of good materials. If you get a chance to check it out at your local library, do so. But I didn't want to be constrained nor limited by a singular book. I wanted to have the opportunity to look at many different sources. Now, last week we also used, this is almost an elementary book. I got it from the library. But I wanted to help you understand certiorari. And when we talk about a petition for certiorari, a petition that was just recently filed in a case that I had worked on for many, many years. Certiorari is essentially telling the lower courts, send us all the documents. And I thought that this particular book, the Supreme Court A to Z, almost encyclopedic in nature as it relates to the sole topic of the Supreme Court, I thought it had a elementary description of the petition for certiorari, and I thought it was well worthwhile in sharing with you. I've looked at many other books. As I've looked at many other books, this one here is the Supreme Court, the beginnings and its justices, up from the inception of the court to 1991. Some good material in there. But as we begin to focus now in our 4th week up on the final exam, and you go, wow, we're already focusing upon the final exam. We haven't even taken the midterm, which will occur in week 5. Why it is so important for you to focus upon and begin planning for the final exam is because that's going to be that 10 to 20 page written paper where you get to choose a particular Supreme Court justice that you would like to examine, or a particular Supreme Court era. When we talk about eras of Supreme Courts, here we're going to see that former Justice John Paul Stevens, who retired in 2010, he's now written several books about his tenure on the Supreme Court. His most recent book that just came out in April, his most recent book actually talks about how he would amend the Constitution. One of the more controversial statements, and he even admits in his book, not this book, but another book, he even admits that he would essentially do away with the Second Amendment and say that citizens do not have a right to bear arms. He says that he thinks, as he opines, that the Second Amendment has been misconstrued and is misguided in its use and interpretation in contemporary society. However, in this particular book, Five Chiefs, I wanted to show you what I would do when I was looking for a particular book. I would just put in some search terms. Go to Google, go to your library. Put in some search terms looking for Supreme Court justices. We looked at the website of the Supreme Court and we saw all the different justices that have served upon the court. And there's over 100. And what we start to see is that some justices gain greater notoriety than others, perhaps because it was based upon their life, their experience, their contributions to society prior to entering upon the Supreme Court, or it could be based upon their contributions after they became either an associate justice or the chief justice. Now here in John Paul Stevens' books, Five Chiefs, you would take a look at the table of contents. And as we take a look here at the table of contents, we're just seeing if it perhaps has any interest to us. We might read a synopsis on Amazon or Google, but when we take a look at the table of contents in this particular book, what we see that Justice John Paul Stevens has written is he has broken it down. He first talks about the 12 justices that came first, and then he focuses upon 5 particular eras. He focuses upon former Supreme Court Chief Justice Fred Vinson, then he moves to Earl Warren. Then he moves to Warren Burger, William Rehnquist, and now the current era, that being of Supreme Court Chief Justice John Roberts. You could do your report either upon one of these eras, and if you're going to focus upon one of the eras, we're not going to focus upon the first 12 chiefs because that really, although it's an era into itself, it's a nebulous era. In other words, there were so many things happening so many different times that people, even contemporarily and even historians, do not necessarily associate, with the exception of Marbury versus Madison, any of these eras having a particular impact. You see, it wasn't really until after the Reformation period, that being after the Civil War, that we really start to see a development, not only in the law, but in the interpretation of the law. What we see here with the eras, according to former Associate Justice John Paul Stevens, is that he focuses upon the Vinson, the Warren, the Burger, the Rehnquist, and the Roberts era. I will tell you that it's very fascinating reading. So as you're taking a look at the table of contents here, it says on page 81, it begins talking about Chief Earl Warren. What I do when I'm trying to examine if I want to invest any time and effort into reading a particular book, I just read the first few pages of maybe a chapter and see if it captures my attention. I think what you're going to find interesting as we start to look here about Chief Justice Earl Warren was that it talks about how he was appointed in a recess appointment in September, and it talks about how President Eisenhower literally picked him from all of the individuals in the country because not only was he supported by Republicans, but he was also supported by Democrats when he ran for governor in the state of California. Now, interestingly, the Burger era is a very interesting era. The Warren era. Warren era is a very interesting era because when the Chief Justice served from 1953 to approximately 1968, what we see is that several criminal justice cases came from that court. We, of course, have Mapp versus Ohio, which was given to us in 1961, and that expanded the use of the 14th Amendment to all of the states with selective incorporation of the particular amendments. That's a fascinating era, and it was a fascinating time. And as you read about Chief Justice Warren, what you're actually going to find out is that, yes, he was a legal tactician, but he was more concerned about the ethical and political propriety of a particular decision. He talks about Chief Justice Warren being a consensus builder. So not only do we get Mapp versus Ohio, but we get the case that so many of us refer to, and that is the Miranda case, Miranda versus Arizona. We, of course, got that in June 13th, 1966. But even all those cases, of course, we had to have Mapp versus Ohio as a building block. Anybody that hears me talk about police, about the criminal justice system, about courts, will understand that I think the second most important date in all of law enforcement is June 10, 1968, when that particular court gave us Terry versus Ohio and expanded law enforcement latitude, expanded law enforcement's ability to make decisions right there on the state or right there on the street that judges nor attorneys could not make them themselves. And they did so based upon a lesser standard called reasonable suspicion, whereas the Supreme Court, through its interpretations of the Fourth Amendment, has always said that those 54 words require probable cause. It's a fascinating case for the time. Well, I would read a little bit of that, and then of course I would go to the Burger Court. The Burger Court, I remember as I was growing up, Warren Burger was the Chief Justice. He left office in 1986, right before I got out of high school, and then he died while I was still in law school in 1995. The Burger Court, very interesting because Warren Burger, I still remember reading his one-page will that he had written. Here was a legal practitioner who wrote a one-page will and did not protect all of his family assets for the beneficiaries of his estate. I was awestruck by that in 1995 and remain so still. But after I've read about him, I see that part of his eccentricity, I see that part of his legacy was that his legal acumen was actually considered inferior to that of the other associate justices. And perhaps that's one of the reasons he was deemed aloof. He was deemed as a lone wolf and not quite the consensus builder that the Warren Court was. Then, of course, we go to Chief Justice William Rehnquist, and then we go to Chief Justice John Roberts. You can do your report on one of those eras. If you choose not to do your report on one of those eras, then I suggest you start looking at some other books. Now, here is a book by Jeffrey Toobin. It's called The Nine. This delves into all of the different nuances of the Supreme Court justices and how these 9 people at their particular point in time affect the rest of the 300 and now 16 million people in America. Of course, there's so many other books here that you could take a look at. And as you do take a look at them, one of my personal favorites is Antonin Scalia. Now, as we take a look at Antonin Scalia's book, or the book about him, there is an article that we will later read about Justice Scalia's vision and his rationale in interpreting the Constitution. But you could choose a particular justice, and Antonin Scalia would certainly be one that I would choose. Now, another most recent justice, of course, Stephen Breyer, and you could do your report on him. But you don't have to stay contemporary. You don't have to stay within the confines of your lifetime. You can instead examine any of the justices, any of the chief justices, or focus upon a particular Supreme Court era. Here is Kenneth Starr, who investigated Bill Clinton, former President Bill Clinton. He has a book here called First Among Equals, The Supreme Court in American's Life. You could, of course, use that as one of your sources. Radicals and Robes. Now, Cass Sunstein, I've read some of his materials. We'll say he's very liberal in his approach and in his writing. Very good, very informative, and whether you consider yourself conservative or liberal, it's always important as academics, as people who are trying to make reasoned decisions, that you simply examine both sides of the issue. Those are just some of the books that I have been reviewing, that I still have here with me at my house, that I've been reviewing in preparation for CRJ400. What I encourage you to do this week, and part of your assignment is going to be, yes, you're going to have 1 and 2 news briefs due, but your discussion board question is going to be very simple. You're going to identify which topic you're going to research. Is it going to be a particular Supreme Court era, or is it going to be a particular justice of the Supreme Court? You have complete freedom to choose, but making certain that you understand, that's why I'm coming to you through video today, was that you need to make certain that you start doing the reading now. Your actual written paper, I'll give you a format in greater detail later, but it is going to require that you have at least 3 sources. Any one of these books that I mentioned here, or a combination of these books, or a combination of any books related to the Supreme Court will serve and suffice for your 3 sources. You need to take action. I know how many days it took me to go around and picking these particular books. If you are anything like me, you go to the library, you do some research, you start pulling books, or if your library doesn't have those books, then you need to start pulling those books from library consortiums, which is part of how I received some of these books, is I ordered them through different libraries and then they were eventually sent to my home library. It's going to take you some time. You're going to have to read these books. 25% of your grade will be based upon the final exam, and the final exam is this 10 to 20 page written work product, written by you, researched by you, but all for your enlightenment. And remember, most importantly, we're having fun. We're having fun here in the summer. Now, I like teaching summer classes because, especially this particular summer class, other summer classes that I've taught, I don't have quite as much liberty, as much freedom, because I have to get through certain pieces of material. Here, we get to create whatever it is that we want to study. We are studying the Supreme Court. Well, if you have any questions, make certain that you email. If you have any questions you want to talk to me about, just pick up the phone, give me a call, area code 614-875-4174, and I look forward to learning some more on my own as I, of course, lead you on this journey to experience the Supreme Court. Until next time, take care.